Today on the Euro Express, we head to Brussels and then to Strasbourg, where we pick up two lawyers, one Irish living in France in Strasbourg and the other Romanian living in Brussels. Adina Portaru works with the European institutions at the European Union in Brussels, whereas Lorcan Price works with the European Court of Justice based at Strasbourg. Lorcan and Adina, welcome on board the Euro Express.
Thank you,
Thank you for having us.
Now, I'm going to have to say that about the European Court of Justice, Lorcan, I'm, like most Europeans, pretty ignorant. I've heard the name. I know they do something around human rights, but I'm never quite sure. Are they part of the European Union? Are they not? Explain to me.
Well, that's a very good question, Kevin. In fact, the distinction between them confuses a lot of lawyers as well, because one of them, that is the European Court of Justice, is based in Luxembourg, and that court deals exclusively with European Union issues. So it concerns the law of the treaties of the European Union, and therefore it only applies to the 27 countries that are member states of the European Union. So anything there to do with disputes over European Union law could ultimately end up before the General Court and the Court of Justice in Luxembourg. Whereas when it comes to the Court of Human Rights, the European Court of Human Rights, that's based here in Strasbourg. And that has a much broader jurisdiction than just the 27 countries in the European Union. That actually involves 47 countries across Europe and beyond the geographical borders of Europe. So it stretches really from my own hometown in Galway on the west coast of Ireland, all the way across Russia to Vladivostok, and includes every country in between. So it's an enormous jurisdiction of about 800 million people, including Turkey, Azerbaijan, Armenia, the Caucasus, and Russia, of course. And in that sense, countries that have signed the European Convention on Human Rights, so all of those 47 countries that are in the Council of Europe, any citizen in those countries can bring a case to the Strasbourg Court, the European Court of Human Rights, where they believe that their authorities in their own country have breached their human rights. And principally, that would involve, obviously, any breaches of the convention, but there are also protocols to the convention as well. Although you are required, first of all, to try and settle the issue in your own domestic courts. But if you're not happy with their decision, you can take your case to Strasbourg, as the expression goes. So because of that direct right of petition, and because of the huge jurisdiction that the court has on human rights issues, it has been very influential on human rights questions and jurisprudence in Europe. But then, of course, the Court of Justice is also very important if you're in the European Union, because the European Union also has a Charter of Fundamental Rights now. And that means that in what we will see in the future after the Lisbon Treaty is the court in Luxembourg already, it's begun starting to develop a human rights jurisprudence about some of the very important questions, obviously, in how we live our lives and how we conceptualize our rights as individual citizens.
So, Adina, your role is within the European Court of Justice, so you work within the European institutions linked to the European Union.
Thank you, Kevin. Well, the institutions obviously go beyond the European Court of Justice. So my role in Brussels is to monitor legislation coming from the European Commission, the European Council, looking into what is happening in the European Parliament, where are so many resolutions, so many declarations going around. And then, of course, there is the European Court of Justice, which is the court of the European Union. So it's a very complex system that allows legislation to flow from different sides and having debates on different sides. And my role is indeed to monitor all of these instances and to give recommendations also on good language protections of fundamental human rights.
Now, both of you are lawyers, and it will not have escaped the notice of the viewers that we have an Irishman in Strasbourg and a Romanian in Brussels. And that is because you're working for ADF International, which is an international advocacy human rights organisation. So your particular roles, both at Strasbourg and Brussels, are around issues of freedom of speech and freedom of religion. Would that be a fair way of summing up why you're in those particular locations?
Kevin, we are at the different institutions to advocate for religious freedom, marriage and family, freedom of expression. So issues that go beyond, let's say, the two issues that you've mentioned on religious freedom and freedom of speech. Mm-hmm. Now, particularly, my expertise lies in religious freedom. As you rightly said, I'm a lawyer in the Bucharest bar in Romania. And then from that point on, I moved actually to do academic studies in the Netherlands, in Maastricht and in Austria. And in Austria, I was a research assistant and doing my doctorate studies in religious freedom. So my thesis analyzes the way that religious freedom is protected and also promoted by the European Court of Human Rights on the one hand, and then by the United Nations Human Rights Committee on the other hand, with two focuses, basically on the wearing of religious symbols and conscientious objection to military service. And from that capacity, I got to then move to ADF International, which is indeed a human rights organization protecting and promoting fundamental freedoms and the inherent dignity of all people. And in Brussels, as I said, my main focus is religious freedom, but I'm also dealing with issues concerning, for example, parental rights, marriage and family, procedural law at the European Union, freedom of speech. So it's a wider palette of fundamental rights, really, and we see these rights being interlinked. So that's very simplistic description of our role there in Brussels.
Would you say, Lorcan, that's how Adina summed that up masterfully, that's your sort of remit within the European Court of Human Rights then? You're doing the same work as she's doing, but it's within that framework, scrutinising the legislation, or is it more advocacy role at the court?
Well, I would say I'm a practicing barrister, so I'm still a member of the Irish Bar, obviously, and I have a practice there. And principally, what my work for ADF entails is legal advocacy at the European Court of Human Rights. So that would be very much direct representation of clients. So my colleagues and I are involved in representing individual applicants as their counsel on record before the European Court of Human Rights. But we also provide advice to others who are taking applications, and we intervene as legal experts, what are called third-party interveners. Our American friends may recognize that as a type of amicus curiae, where the court invites you to submit a view on a particular issue and to give a general expertise. So that's principally what I do here. Unlike Adina, we don't have a really the same kind of permanent political structure in Strasbourg in the Council of Europe. Now, confusingly, the European Parliament does sit here occasionally, but it's a totally separate institution, and there is a parliamentary assembly attached to the Council of Europe, but it really only acts in an advisory capacity, unlike the European Parliament that has more powers. So my work would be more directly legal advocacy, certainly on behalf of ADF in these matters.
It's worth just maybe explaining again the origins of both of these kind of legal structures, because the European Court of Human Rights came out of the Second World War, I think I'm right in saying, Lorcan, and it was developed on a pan-European basis outside the framework of the European Union or the European Economic Union as it was, the EEC, or how it started way back in late 40s, early 50s. So there are two very separate entities within the same landmass or within the same continent. Can I just ask you on a practical, you're both lawyers, you're both working internationally. I mean, are your rights of call within your respective jurisdictions then allowing you to operate, or do you have to find new means of operating within different jurisdictions? How does that sort of work?
Well, I might take that first. I'm, as I say, still an accredited member of the Irish Bar, so my right of audience directly is before the courts in the Republic of Ireland. But as far as the European Court of Human Rights is concerned, if you are accredited at any bar within the 47 member states, then you're entitled to represent somebody at the court in Strasbourg. Now, principally, if I were practicing in Ireland, I require a solicitor as part of the legal team, which is one of the unusual quirks of the common law system in the UK and Ireland. Whereas our American friends just hire a lawyer and they go into courts. Obviously, there's distinctions between trial lawyers and other kind of lawyers. but principally they all have the same right of audience. Whereas in Strasbourg, the only hurdle you have to cross is to show that you are in fact an accredited lawyer of some description in any of the 47 member states. So that's what gives me my right of audience, as it were, before the court. Now, if I found myself in a position where we were actually arguing a case directly before the judges, I would be part of a legal team there
Yes.
with my colleagues, some of whom are solicitors and so on. So it's a very collaborative effort. And even though my colleague Adina is in Brussels, it really is the case that we're presented with human rights issues that can be cross-jurisdictional and complicated. We draw in expertise from right across the team of colleagues and allied attorneys that we have, is because very often when you find yourself, let's say, fighting a case to do with freedom of speech in Finland, for example, comparative law from other jurisdictions becomes very important before an international court.
Yes.
So you need to look at the United Nations standards. You need to look at any relevant law that from the European Union, either in terms of political declarations and so on from the Parliament, or decisions from the European Court of Justice. And then you look at the big courts around Europe and indeed around the world, be it the United States Supreme Court or the High Court of Australia, or the Supreme Court in the United Kingdom, or the German Constitutional Court. You look at decisions from those courts that are relevant to the issue that you're arguing about, and you bring those before the European Court of Human Rights as well. So when you're dealing with these kind of human rights issues at the international level, it's important to try and draw as many comparative law examples from right around the world, which does make it quite different from domestic courts. So,
Yes.
for example, in the United States, if you were before a federal court, or indeed the United States Supreme Court, which is the top federal court, obviously, the top court in the land, there is a reluctance with many judges, frankly, that I agree with, to allow too many international law arguments to try and give an insight into how the US Constitution or US statutes ought to be interpreted.
Yes.
It's quite different in Europe with the international courts. They want to hear how other courts around Europe are interpreting things, and very often that's some of the expertise that we bring to bear when we intervene. So it's important to make clear the courts in Luxembourg for the European Union and the court here in Strasbourg for the European Court of Human Rights, they're not at all like the federal courts in the United States. They're totally different. They do not have the type of jurisdiction that the courts in the United States have, because, of course, Europe isn't a country. These are states that are bound together by agreements in forms of treaties. There is no sovereign state with a constitution and so on that is, a European state.
That's a very, very interesting. I wasn't aware of that at all, Lorcan. That's extremely interesting. However, Adina, you're working in Brussels, where you're working with a court within a legal political structure of some sort, which makes laws, and you see how those laws are made. But Lorcan, the way you're describing that, the European Court of Human Rights could be open to international pressure or being pushed in certain directions, which are nothing to do with maybe Europe or nothing to do with what the convention was originally designed for. Or am I being too pessimistic about that?
No, I think that's a fair point, insofar as the convention is a treaty that was agreed in the late 40s, early 50s, and since then has been open to countries to join, and 47 countries have joined. But the court adopts a very different view of how to interpret it than, for example, the US judges on the US Supreme Court. And this is a debate that rages across legal and academic circles as to how you take a treaty or a constitution, in the case of the US, and interpret what the words mean. When it comes to Europe, the convention is interpreted by the court here in Strasbourg as what they call a living document. In other words, its meaning is not fixed necessarily at the kind of ideas that were prevalent, let's say, in 1950, but it has to be reinterpreted according to norms and, prevailing ideas that are relevant today. So that does create problems, and there's been criticism internally in the court over the years as to why and how the convention ought to be interpreted. if we kind of use the standard dichotomy between conservative and liberal, yes, there are classically conservative judges, for example, from countries like Poland and Malta and so on, that want to see the convention given a fairly fixed meaning and not allowing the court to use it like a living document to kind of consistently read new interpretations into it.
Adina, in the European Court of Justice, within the EU framework, are things a little bit more easier in terms of this? Do all the member states have judges designated to the court, or how does it work?
Indeed. So I think on the EU level, we have to make the distinction between the laws coming from the Commission, European Commission, and the Council of the European Union, which is really a very complex process of negotiation, presentation, and then adoption. And then what is happening at the European Court of Justice, because even though the court is moving steadily towards also interpreting human rights, especially now with the EU Charter for Fundamental Rights, it is more technical, it is less open to such interpretations. Now, cases at the European Court of Justice can come if there is a lack of implementation or an incorrect implementation of an EU act, let's say in competition law, financial aspects and so on, or could happen as requested by a national court, a judge of one of the 27 member states, because they are not sure about the meaning of an EU term or of an EU regulation. So, for example, there was a landmark case very recently, a couple of years ago, regarding the definition of spouse in EU free movement legislation. What does a spouse mean? Because we have different legal systems, different regulations in different countries that define what marriage is. So a couple that is moving across borders may not be recognized as according to the status acquired in one country. So one of the judges actually from Romania, one of the courts, the Constitutional Court of Romania, asked the Court of Justice, okay, how are we to interpret the notion of spouses or partners in the EU free movement aspect and directive? Because we're not really sure what the EU wants to say about it. And then the court goes into looking into that issue. And one of the big differences between the judgment coming from the European Court of Human Rights compared to the European Court of Justice is that the judgment at the European Court of Human Rights in Strasbourg, where Lorcan is active, is binding in principle only among the parties that are at that specific case. So let's say it is a case against Italy. In principle, the judgment is binding against Italy. However, it has a persuasive effect on other countries. Sure. But another country can say we're in a different position, we have a different system, a different legal setting, and so on. And then the court can go more into looking into those specificities. Now, at the European Court of Justice in Luxembourg, the situation is not that flexible in the sense that once the European Court of Justice says the definition of, let's say, spouses or any other term that they may be analyzing is this, then the courts in those countries, in all 27 member states, have to take that definition and apply it to the case. So there is less room for maneuver. And then also one of the aspects, if I may, regarding those proceedings is that once a case is brought, for example, from Romania, all the countries in the European Union have the flexibility, the opportunity to intervene. They can come before the European Court of Justice and say what their position is. There is no third-party intervention, as Lorcan mentioned, is the case at the European Court of Human Rights. So human rights organizations cannot simply intervene and say their point of view and recommend its solution, even based on long-standing experience on that, because the rule at Luxembourg, at the European Court of Justice, is that you can present arguments only if you're considered a party. So you have to be a party at the national level before that case is submitted to the European Court of Justice in order to be able to intervene. So the rules are quite different, and also the ways of interpreting and applying human rights or the rules within the international organizations are quite different.
Okay. So thank you both. That's extremely helpful in setting the framework we're working within. But I'd like to sort of discuss with you the current state of freedom of religion in particular across Europe, both with what you're seeing, Lorcan, the cases that you're involved in at the European Court of Human Rights, and also within the EU at the European Court of Justice, and how, because what you're suggesting there, Adina, is that the European Court of Justice seems to have a great deal of power in defining what certain things are, and one can immediately see how defining something brought from a British case has a major impact in Romania or in Poland or wherever, where there may be a different culture, a different understanding of these things. So, I mean, how would you sum up the position of freedom of religion across Europe today?
That's a very good question, because it's a complicated question. It depends on where you are, is the short answer. If you find yourself, let's say, in countries of the former Eastern Bloc, one of the principal things we're seeing there are administrative barriers to being able to open churches, establish religious communities, and so on. I'm just thinking of Russia, for example, has passed in recent years anti-terrorism legislation that requires any person who wishes to establish a religious organization or a community to apply to the Russian Interior Ministry. They will decide whether or not you're entitled to open it. They'll also want to review literature that you may have, pass certain regulations about where you can gather, and so on and so forth. And these go beyond things that we might be familiar with in terms of just simple incorporating a charity or a legal entity, and having planning permission and so on to set up a physical church. This is more a level of control over who can set up, who you are, what you're teaching, and so on and so forth. So in Russia, you're seeing that really a very strong clampdown on who can come into the country, missionaries and so on, and what they can teach, and whether or not they are able to even establish and open churches or establish a legal entity, an incorporated entity. We're in the process, my colleagues, of representing a number of different clients who have small community churches who are being shut down under this law and planning laws as well, which are being used fairly illiberally against kind of small religious communities. Particularly, there's hostility to evangelical Protestants because of the feeling that they're connected to the United States and they're seen as a kind of an intrusive foreign influence. Then if you move across Europe, let's say to the west, to the United Kingdom and Ireland and France and places like that, it's a very different type of let's say, persecution is a word that I have seen used. I would probably say, let's say, oppressive or unwarranted interferences with religious manifestation and practice. So a lot of that comes through anti-discrimination law, and you find that people who want to freely live out their faith in public, be they bakers or people who are involved in wedding planning or photographers and so on, find themselves at the wrong end of anti-discrimination law, and it's used to force them and compel them to do things that they don't want to do. And a good example of this that we're currently involved in is the what's known as the Asher's Bakery case from our own island, from Belfast, where the MacArthur family are Christians. They have a bakery employing 50 or 60 people in a number of different shops around Belfast. They refused in, I think it was around 2014, to make a cake with the inscription "Support Gay Marriage" on it. And the person who wanted that cake then sued the MacArthur family and the bakery in court under anti-discrimination law to force them to make the cake and to compensate him and so on. And he was initially, Gareth Lee was the name of the man. He's an activist, political activist. He was initially successful in the courts in Northern Ireland, and he lost before the Supreme Court then in London. Now, it's a little bit more complicated than that, because his case was actually taken up by the Human Rights Commission. So he wasn't directly a party himself, or he wasn't a principal moving party, let's say. But he himself now has taken the case to Strasbourg, complaining essentially that the Supreme Court in London should have found in his favour and should have, fined the MacArthur family for refusing to make the cake with "Support Gay Marriage" on it. So we're intervening in that case at the moment as well. So it's an interesting spread of issues to do with freedom of religion. Whether you're in Russia, they're closing your church down, or they're censoring the materials you're reading. And if you're in Western Europe, increasingly you're being compelled to do things that you find deeply objectionable and against your conscience. And the court in Strasbourg finds itself at the center of these type of complaints, trying to balance the right to freedom of religion that's contained in Article 9 of the Convention. And that's a very long-standing and very strong provision protecting freedom of religion because, as of course we know, when the Convention was written in the late 1940s, Europe was just emerging from the Second World War, yes, where there was extraordinary persecution of religious minorities by totalitarian regimes. And sadly, that continued right up until the fall of communism. So countries that emerged from the Soviet bloc as well had a lamentable history of persecution of religious communities and so on. So the court in Strasbourg has a big role to play here. And our hope is that they will do what the founders or what the drafters of the convention intended, which was to give the maximum freedom and space to religious expression possible. Now, that's not to say that anti-discrimination law should be completely ignored, but where there's no evidence whatsoever that compelling somebody to do something deeply against their conscience actually helps anybody, whether it's the person requesting the cake, to use my example, or anything else. Creating a society where people are forced to do something against their strongly held beliefs does not help anyone in society ultimately.
Absolutely. Adina, the European Union famously didn't want anything to do with religion or God when it was constructing its constitution. And to many looking on, the European Union increasingly legislates for equality rather than freedom of religion. That's what's going to trump any kind of legal debate. Is the European Union and the kind of cases you see at the European Court of Justice just a never-ending restriction and slow burn persecution of people of all religions within the European Union?
Kevin, I wouldn't be so pessimistic. So first to say that religious freedom
I was
would
being
not be
deliberately pessimistic, so I'm glad you're not. Tell me why.
There is no antithesis as such between equality and religious freedom. So I guess we should renounce this clash between equality and religious freedom. It all stands in the details, of course, what kind of religious freedom we seek for, what kind of manifestation, what kind of, let's say, content to equality and the situations. And we as lawyers know that this is really on a case-by-case basis, but we need to stand to the basics and the content of fundamental human rights. And then in terms of what the European Union can and should do, now there are many mechanisms to protect religious freedom and to promote it, either internally or externally. Now, obviously, the question of whether we could do more or whether those are used to their potential is a different debate. But look, the European Union has ways to promote religious freedom internally. It has the famous Article 17 dialogue. It doesn't sound very attractive, but people in Brussels would know what I'm talking about.
What is that? Explain that to our viewers. What is
sure.
Article 17?
Sure. It is the article which regulates the dialogue between the European Union institutions and religious faith communities, churches, and also secular and non-religious organizations, secular organizations. So even though the reference to Christianity did not go into the treaties, this article is meant to, on the one hand, promote the neutrality of the European Union with regards to these religious or non-religious groups and churches and associations. And then on the other hand, to try to have actually a dialogue with them to reach certain objectives or to reach certain aims. It's very difficult to say to what extent that is, let's say, a concrete way of the EU to engage, but that structure exists and that there is a lot of potential internally, at least on that side. And then externally, we have many mechanisms. I would say the most prominent, and I would like to just say a couple of words on that, is the European Union Special Envoy for the Promotion and Protection of Freedom of Religion or Belief outside the EU. So when we speak about external side, is really what European Union officials and institutions are doing when they're negotiating certain treaties, conventions, or going into trips, field trips to third countries, countries that are not part of the European Union. This position is still rather new. It was established in 2016 after the European Parliament adopted a resolution recognizing that what ISIS is doing in the Middle East towards Christians and Yazidis and other religious and ethnic minorities qualifies as genocide. Yes. So it was a groundbreaking resolution. It was a very firm position of the European Parliament, which at that point called for a permanent special representative for freedom of religion or belief outside. Because obviously the question was, we recognize now that this is genocide, but what shall we do? What do we do concretely about it? So this position was called for. The establishment of the special envoy, which is a weaker position than a special representative, happened in 2016. It was fulfilled for 3 years by Mr. Jan Figel. And now this brings me to the second point. Are we using the mechanisms to their full extent? That position has been renewed very recently, 3 months ago, after almost 1 year of silence coming from the European Union, when people were not really aware or knowing whether the position will be renewed, what is going on. Is the European Union simply turning a blind eye to the religious persecution in many countries and many parts of the world? So now we have this announcement coming 3 months ago that there will be a new special envoy. And 3 months after, and almost 1 year after the end of the mandate of the former special envoy, we do not have any clarity on the position, on the name, on the content, and so on. So, it's encouraging to know that this position will continue to exist. But then again, there are many question marks on why that appointment takes so much time. And also what is happening really to the victims of persecution on the ground, which are now lacking a partner of dialogue in the European Union on this point.
Can I ask you, Adina, because sometimes looking at the European Union and the Parliament from a UK, a London perspective, I'm wondering if I see it through that prism, because as you're talking, I'm interested that many other countries are represented there with very distinctive cultures which are maybe more overtly religious than the United Kingdom is today. Would you say that maybe my pessimism, as you described it correctly at the beginning, is coloured a little bit by that situation, that I'm looking at it from a London perspective, or if it was a Dublin perspective, or even Paris, where the clash between the secular and the religious is always ongoing? Maybe it's less so in other parts of the European Union.
Yeah, I mean, what I was referring to was really the fact that the European Union is a tremendous international organization. It has a lot of potential to advance fundamental freedoms, among which the right to freedom of religion or belief. And then we have to be very careful that in the treaties, when we speak about freedom of religion or belief, that also entails the belief side, which is the secular side, the humanistic side, and so on.
Right.
And I believe that in such international organization setting, there is and there should be a dialogue between the different sides, and there should be a way to reconcile the different, let's say, claims or the different challenges. Mm-hmm. But of course, it is also inevitable that there will be different clashes because the claims are different and sometimes they go against each other.
Yes.
And here is the question of how are we using these instruments to their full potential? Are we just speaking about dialogues over dialogues and with no concrete effect? Whereas the institutions carry on doing their own legislation, which may not be favorable to freedom of religion or expressions of freedom of religion. All these are really fascinating questions, and these are also one of the rationale why we're based in Brussels to monitor this. I mean, imagine if I were in Romania and doing this kind of work, it would have been very, very difficult to get the first-hand information about what is going on in the institutions.
Talking of clashes, though, Lorcan, courts, especially somewhere like the European Court of Human Rights, is always a place of clashes, right? Nobody turns up because they're in a good mood to tell everybody that. They're coming there because there is a problem somewhere and somebody wants it resolved, and there has to be a winner and there has to be a loser in that situation. I mean, do you see within the European Court of Human Rights, how can I put this, a slant towards religious freedom, or a resistance to it, or is it so complex that it's different? It's a case by case basis.
Well, I think yes, it is complicated. I will say this much: the people who drafted the European Convention were very clear about the importance of needing to protect freedom of religion, and in early decisions about freedom of religion, the court itself used the language that it was a hard-won freedom, that there'd been centuries of bloodshed in Europe over religious issues. I mean, European history, as we know, is coloured by wars of religion, and even into the 20th century, in the late 20th century, we saw religious persecution on a fairly large scale. One of the most horrific genocides in the 20th century in Europe, let's say in the latter half of the 20th century, was in Yugoslavia, the former Yugoslavia, and Srebrenica and places. So this isn't an old question. It's it's a question that occupies us right now. And the court, I think, is aware of that. It has used very strong language. The issues, I suppose, the problem arise where there's a clash or a tension between other more, let's say, in increasingly diverse societies. How do you accommodate people who are making claims about their sexual orientation, or other religious minorities, where they say that a Christian organization or a Christian church or Christians in business are discriminating against them? And that is a complicated issue to resolve, because the court in Strasbourg is faced with a number of competing claims where, as you correctly said, nobody arrives there happy with what has happened necessarily in their own jurisdiction. And what the court has to do, I suppose, is to try and ensure that in protecting equality and these other worthy aims, that it doesn't then devalue the clear protections for religious freedom that exist in the convention and in its own case law as well. And as I mentioned earlier, one of the problems, of course, is that the range of practical issues that arise across Europe, whether it be your church is being bulldozed or shut down in Russia versus, can you operate your business as a Christian, as somebody who believes sincerely in living out their faith in their commercial activities in the UK or France or so on. And the court, I think, has a difficult task in trying to balance that. I am a critic of the court in a number of ways, but I think in fairness to the judges there, we do have to recognise that it's not a straight-cut issue where they're presented with competing claims and where the national courts have had their own decision already that they have to take into account as well.
But Lorcan, can I ask about the European Court of Human Rights? Because, although Adina's court, you can draw a sort of line around its jurisdiction, and you can see how legislation has evolved over the years of the European Union and so on. And it's similar to many jurisdictions in terms of how laws come about. But the European Convention has such an expansive area with so many different cultures, so many different religions, so many different understandings and history and all the rest of it. I mean, the whole from the Urals to, as you say, the Atlantic coast. First of all, on a practical level, if I was to take a case to the European Court of Human Rights around an issue of freedom of religion, are we talking years before I get a hearing? And secondly, how do they deal with so many sort of cultures all pitching up at Strasbourg, demanding justice from very diverse backgrounds?
Well, I'll answer the first part of that first, which is that it used to be it could take 5 or 6 years to have your case determined by the court. And that was an outrageous situation, considering that one of the things the court has to do is ensure that there's a right to a fair hearing under Article 6 of the Convention in different countries. So you had a bizarre situation where the court in Strasbourg was criticising the Italian courts for being so slow in making a decision, when it itself had this crazy backlog of cases. Now, they've gotten faster. I'm reluctant to give a hard or fast number, but I think you could probably hope to see your case, if it was accepted, determined in 2 to 3 years, which sounds long, but is a dramatic improvement over where they were. The second question is, the second part of your question is a fascinating issue, which is correct. Europe is a very diverse place. I mean, if you think, for example, Azerbaijan is a predominantly Muslim country, and it is in the convention. My own country, the Republic of Ireland, is a predominantly Christian Catholic country. And so how is it that the court can arrive at a conclusion as to what is the nature of the family, marriage, and so on? And they don't do a good job of this, because there is a tendency to try and enforce, in my view, a Western European liberal conception of things to do with recognizing certain types of relationship that really have, I think, very little resonance in places in the Caucasus or Turkey and so on. Yes. And I think the principled approach here should be to try and not enforce a given worldview on all the countries, all the 47 countries. They do have to ensure respect for the Convention, respect for the rule of law and democracy. That's what the European Convention is about. That's what the Council of Europe is about. But trying to take 47 countries and fit them into a straitjacket about how they ought to recognize different types of relationships, whether or not businesses are required to print political slogans on top of cakes. I mean, I think that is a very foolish way to approach it. And that's why I think the court needs to essentially disengage or back off, as it were, on forcing a particular worldview on very diverse countries. And they themselves recognize that in a lot of their decisions. They recognize that the court itself is not an appeal court. It's only there to review whether or not the convention has been complied with, and so on. And they do use that. But then in the same breath, they will go on to make findings that suggest they have a particular view that they want to force on countries. So like everything in the law, it's in many ways, particularly when you reach this level of kind of human rights law or constitutional law, where there are fundamental rights and freedoms at stake, you find, again, ultimately a political and a prudential clash as to whether or not the court needs to be more activist or less activist, whether or not it needs to disengage from giving a certain point of view on things, or whether or not there is actually an evolving human right that needs to be protected. And where we find ourselves, obviously, in our activity is trying to ensure that in the midst of this clash of what rights need to be protected and how the balance needs to be struck, that religious freedom isn't ignored, isn't left out of the mix. And I think that's increasingly important, where people are claiming to be offended by the expression of certain religious points of view, or they're trying to force, as I was saying, religious business owners to comply with certain anti-discrimination laws and make certain demands of them. We cannot have a situation where, 70, 80 years after the convention was agreed, that one of the principal rights in it is being slowly eroded over time.
Yeah. Adina, in the European Union, some of the criticisms of the European project is precisely the sort of problem that Lorcan's alluding to, that they have a mindset, that there is a mindset, that something that they are propagating in political and quasi-legal ways across the European Union. First of all, is that a fair estimation of that? And secondly, can you point to any cases in the European Court of Justice where you can say that the freedom of religion was respected, that a case came and it demonstrates that there is a plurality of opinion within the European Union on this matter?
Yeah, so I would first respond and actually continue the line that Lorcan had in his response, in the sense that we should not forget that the motto of the European Union has been and is still united in diversity. So this is something that we tend to overlook within this greater structure, as you said, with a discourse that tends to show, let's say, one way only of how things are done. I like the point that you've mentioned regarding the quasi-legal aspect, because I think that is exactly the issue. We're not speaking that much about laws that would directly contradict these fundamental rights. Of course, they can be misinterpreted or misapplied, but I think the greatest danger in that way, in the question that you've asked, comes from, for example, the European Parliament, in the resolutions, declarations that it has. These are acts that don't have a legally binding power, so they are not laws as the ones coming from the Commission and Council, but they are so frequent, and it's very, very difficult to track all of them. It's really impossible for anyone to track, and I might say even for members of the European Parliament, to know the specificities of each and every resolution that they're voting in the committee or in the plenary. Because, a member of the European Parliament who may be, let's say, a journalist by profession, is part of the Committee on Fisheries or Agriculture, Women's Rights Committee, Equality, and so on. These are very technical committees, and the drafts also contain certain traps, so to say, that a lawyer or would know best rather than a politician or a journalist, and so on. And these members of the European Parliament, as in many other places, rely a lot on the advice of the assistants or political advisors. So it is a mechanism by which you have 700 or more than 700 members of the European Parliament gearing towards adopting all these resolutions and declarations. And the issue is, on the one hand, maybe in the voting, and in the content that is being delivered to these committees and to the members of the European Parliament, but also in a lack of education, I think, across member states, because I would speak only of my home country, of Romania. You know, you make a headline saying the European Parliament declared that, I don't know, prejudiced speech might be now eradicated in all institutions, and we must have a gender official in every institution in the country. Now, the regular reader would say this is a law that was adopted by one of the highest institutions in Europe, and it must be binding. Nobody's really saying this was adopted by this mechanism that adopts, I don't know how many other resolutions within a month, and it actually doesn't have a legally binding power. And it actually isn't, or is very rarely also checked regarding these specificities. Right. So I think the issue comes, as you said, from the quasi-judicial or quasi-legal, actually, mechanism that really delivers endless papers, and the way that these papers are then portrayed in the media. Then going to your second question regarding the Court of Justice of the European Union, so it's really gradually going into issues of religious freedom. It's not a field where it has traditionally had a lot to say, also because of the main focus being financial, economic, also, so not really human rights. But we've seen a growing tendency to go into those issues. It's not an artificial one because, of course, they have to be seized with cases in order to analyze. And most of the cases so far on religious freedom deal with, for example, ritual slaughtering coming from Belgium, question of whether religious communities, mostly Muslim and Jewish here, can pursue their religious slaughtering based on religious beliefs. Then the wearing of religious symbols at work, but this also contains more or refers more to the Muslim community wanting to wear the headscarf at work, but it has a wider question of whether employers are legally entitled to ban all forms of symbols, be them religious or philosophical symbols, yes, from the workplace. Yes. So can they really say we want a space that is totally neutral? What does that mean? You know, does it mean that an employee who has a peace sign, you know, exactly, a necklace with a peace sign should not be allowed to come to work with that because that's a philosophical symbol? Absolutely. So these are wider questions, but the main point is that the Court of Justice has only just begun to look into these aspects, and it will be very, very interesting to see if it's going to go in a different direction than the European Court of Human Rights, because we have these two competing courts in a way. Yes. And especially in the context of the European Union wanting to accede to the European Convention on Human Rights as a whole. So that would create even more complexities that I'm sure listeners would be very bored to hear about. So we'll stop on that point.
I think, Adina, though, you're alluding to a very interesting point as a layman, which is that we talk about freedom of religion and we think of Christianity, we think of Judaism, we think of Islam, we think of traditional religions. But as you've alluded to, there's ideologies at work which are quasi-religious in that they have very committed followers and they have a set of beliefs that they themselves subscribe to, often secular ideals or whatever. And I'm wondering, how do the respective courts and institutions deal with that sort of quasi-religion, or how do you actually define a religion these days in this diverse Europe that we live in?
Yeah, well, I mean, I will let Lorcan discuss about the European Court of Human Rights, who has been very, very generous in interpreting religion or belief in its jurisprudence. But just sharing one aspect of our work. So going back to the famous Article 17 dialogue, which entails this dialogue between the European Union institutions and philosophical religious organizations and churches. So we were asking the officials of one of the institutions at the European Union, but how do you define, let's say, a philosophical organization? Who would be actually qualifying for something like that? Is it a secular organization? Is it a human rights organization that has, let's say, a Christian ethos? Because the way that European institutions are approaching that is to say, okay, if you have the Catholic Church represented within that institution, we will not allow, let's say, a Catholic organization or a Christian organization holding the doctrine of that church because you're already represented. But how do you define that? How do you draw the boundaries? And there is no real definition to that, especially in the European Union, which makes it very difficult to know who your partners of dialogue are and how actually they're pre-selected and how the institutions engage with those.
Lorcan, Adina alluded to the fact that the European Court of Human Rights is very liberal in its interpretation of religion. But I mean, there's a danger in that as well, because I mean, many Christians in Europe are Catholic. There's a very distinct structure, but that's not the norm. A lot of other religions are very vague in who's in them, who's not in them, who's got authority in them, where their laws are, etc., etc. I mean, is there a danger that we could end up with a definition of religion that is so vague that it actually doesn't serve those that are identifiably a religious group?
It's certainly a problem, all right, conceptually putting the boundaries around it, and the court has made some efforts to do that. It talks about a belief having to reach a certain level of seriousness, coherence. It has to be sincerely held, and so on. So one example that jumps to mind was it didn't reach the Strasbourg court, but I think it was a Dutch court or maybe a Belgian court dismissed the idea that the flying spaghetti monster could be a religion. Somebody who probably thought this was terribly funny, tried to claim some sort of tax exemption. And of course, as we know, some of your listeners might know, the flying spaghetti monster was this conceit used by the atheist Richard Dawkins to try and suggest that, anything could be God. I mean, I think, frankly, it's an offensive idea to people who are religious. But in any event, there is a criteria there, as I mentioned, and they do talk about belief and religion almost in the same breath in reaching this kind of level of coherence, seriousness, and cogency. But they have been willing to protect things like, for instance, pacifism when it comes to compulsory military service. One of the things that I think a lot of us would find, where the line is blurred is things like Scientology, where the court in Strasbourg has held that Scientology ought to be protected under the provisions of Article 9 to do with freedom of religion. When it came to Russia, there was an attempt to shut down and ban Scientology communities there. So what is a religion? Well, I think we would have a fairly clear idea, I certainly do, of looking back at the historical and cultural context that Europe emerged out of, the fact that the rights in the European Convention on Human Rights are clearly grounded in Judeo-Christian values and clearly the notions of equality that we have, while they may have changed ideologically with the French Revolution and then the kind of 19th century secular religions like Romantic nationalism and communism, they're rooted in very much a view of the world that derives itself from Christianity and the idea that every individual single human being is made in the image and likeness of God. So you kind of almost have the afterglow of that, where people are coming along with new religions, new age religions, and belief systems where they want protection for those from the court. And in principle, I think the important thing that has to be done, and you kind of mentioned it yourself, is to ensure that in protecting these things, these newer ideas, that we don't in any way lose the protection or even the coherence of why the right was put there in the first place, which was to protect freedom of religion and worship. And for Christians of all denominations, these things become more acute as you find the law, as we've been discussing, intruding more and more into their daily lives and into the way in which they can worship. And that is true whether you are in Moscow or London or Paris or Berlin and so on, that this finely tuned balance, as it were, that the court is trying to uphold, sometimes they fall on the wrong side of it. And I do think the court has, for example, really lost its way slightly when it comes to protecting conscientious objection. We saw there were midwives in Sweden, Christian midwives, we were involved in supporting their case, who made their way through the Swedish courts, where they were essentially told that unless they performed abortions, they would not be able to retain their employment in Swedish hospitals. They lost in Sweden. They took their case to Strasbourg to uphold their rights clearly protected in Article 9, and the Strasbourg court dismissed the case. It didn't fully consider it. So for me, that was an example of the court saying that if the state requires you to do something that's fundamentally at odds with your sincerely held Christian beliefs in this case, then we're not going to do anything about it here in Strasbourg to protect those beliefs. And I thought that was a very sad day for the court. My concern is we'll see more of those cases where more and more you find regulations, anti-discrimination law, employment law interfering with people's religious expression.
Well, we've come to the end of our journey. It's been an amazing journey through the court systems of Europe at such a high level, and I'm sure I'm not the only one very, very grateful for all the work that you and your colleagues in ADF International do, both Strasbourg, Brussels and elsewhere, in defending religious freedom across Europe, from Galway in the west to the Urals in the east. I know that people can rely on ADF International to advise, assist and befriend people in very, very difficult circumstances. So Lorcan in Strasbourg and Adina in Brussels, thank you very much for coming on the Euro Express, and I very much hope to welcome you on board again in the not too distant future.
Thank you for having us.
Thank you.